part will be about before adhering to Madrid Protocol, what it entailed to us. And then we will talk about our duties as Office of Origin. That will be done by my colleague. And then I will take the floor again for the duties as a designated office. And then finally, my colleague will present the Madrid Online services. So let's start with the first part, our adhesion. So the Madrid Protocol entered into force for the European Union on the 1st of October 2004. Seems yesterday, but it's already 16 years ago. And I've been very lucky to be part of this adventure from the very beginning. So it's like a baby for me that is already 16 years old. When we adhered, we made two declarations, one about the extension of the refusal period. So we asked for the extension to 18 months. And then a second one on the individual fees. So we were asking to receive individual fees for the filing and for the renewal. It took us 3 years of preparation to get there. It was a long, long road to get to the adhesion, as I suppose was also your experience, especially the changes in the law that takes a lot of time. But in parallel to this, we had also to prepare ourselves here at the office. And this entailed changes in the IT system, obviously, preparation and translation of many, many templates in the languages of reference, prepare guidelines, update our website with information about Madrid to guide our client, and of course, training of staff. In these slides, we have copied our regulation. This is the current text because we have been through a reform of our regulation in 2017. So therefore, this is not the text that we had in 2004. This is the update that we went through some years ago. But as to Madrid, we didn't have so many changes in the last reform. We have also copied the link to our guidelines because this is I think of particular interest. It gives some explanation on what we do and why we do it. So it's maybe interesting for you to have a look. So we have put the link here. So let's start with the tool. Originally, we had a different database for international registration and international applications. And we have been keeping it for 15 years. We actually moved to the same database than for EUTM this year. Beginning of this year, we had a big change it was a big change for us. So we moved from an old fashioned database that we had international registrations and applications to the same database that we use for direct filings for EUTMs. This makes our life easier because, as you can imagine, having two databases to keep, to update, it was quite burdensome. So now it's all in the same tool, and it's easier for everybody, for the examiners and for IT colleagues. But we still have some satellite systems that the same actually that we have for EUTMs that communicate with our main database. And this is obviously maintained. This is for the fee management, the correspondence, the possible appeals, publication, and so on. There are many, many small satellite systems that are connected to our main database. And what is really important about one of the very important feature of our database is the automatic detection of ceasing of effects for international application, because we are managing quite a volume of international applications, and it was really necessary to have an automatic detection of ceasing of effect in order to facilitate the work of examiners in this area. This was the case with our old database, and this is the case with the new one. As to communication with WIPO, we started from day one using the MECA XML transactions that WIPO makes available. That was also very important for us to have everything communicated on electronically and not on paper, because with the volume we knew we were going to get, we couldn't afford working on with paper files. So it was quite clear that we had to go in this direction. We receive communication from WIPO electronically as well. So it's not only us sending international applications or letters concerning international registrations, but also all the communication that WIPO is sending, not only the designations, but anything that can affect the designations, the limitation, corrections, renunciation. This is sent also electronically on a weekly basis. As to templates, actually, the way it works is that we do have these electronic transactions activated with WIPO, but to each electronic transaction is connected a letter. For this purpose, we had to develop templates for the necessary transactions. And for international registrations, we had to develop them in the three Madrid protocol languages, because we do accept designations in these three languages, English, French, and Spanish. And for international application, we had to develop also templates for the users, not only for our communications with WIPO, but also for our users. Our regulation foresees that we have to communicate in all EU languages with our users. So we had to develop templates in all EU languages for communicating with the users. So it was quite a lot of work. And these templates were actually, let's say, copied from the templates that WIPO makes available for countries, for offices. The content is basically the same. We give the same message, but it has been adapted, of course, for quoting our regulation on top of the Madrid Protocol regulation. We also quote our regulation, and it's made on our header, of course, of the office. As to the international application forms and subsequent designation forms, we do accept the forms made available by WIPO, but we had to develop as well our own forms, because, as I mentioned before, our regulation foresees that we have to give our customers the forms in all EU languages. So we did translate the MM2 and MM4 forms. We adapted them. We call them EM2 and EM4 forms, and we did translate them into the other languages apart from English, French, and Spanish. And by doing so, we try to simplify those forms by, for example, simplify items 7 and 10. And then we had to add an item 0 in order to be able to indicate the language that the applicant wants to have with WIPO. So here we have an example of a Portuguese EM2 form, and in the item 0, we had to indicate for the client to indicate which language he wants for the treatment of the application with WIPO. And then we added also some parts about fees that were convenient for us, so that they could indicate how they were going to pay the fee with us. As to item 7 and 10, as you can see, in item 7, we deleted the requirement to add the reproduction of the mark, as we are using the representation available in the basic EUTM. So there was no need for the client to attach a reproduction of the mark. It was by default indicated that we were going to use the reproduction of the mark contained in the basic mark. And in item 10, what we did was to give the possibility to indicate that the international application was requested for the whole list of goods and services of the basic UTM, in which case there was no need for the client to indicate the specification in the form. That happened to be very useful because there are, a vast majority of applicants are actually asking the same list for the international application, the same list as in their basic mark. Concerning our website, so we prepared some question and answers specific to Madrid. As you can see here, there are quite a lot of information there. We had also to put online the forms that I just mentioned. Here, this is obviously a copy of our current website, and we have in the meantime already developed an international application online. This is not so many years actually that we are proposing an online application form. It's since 3 years ago that we developed this tool. But in the past, so we were just offering the forms, a link to the WIPO forms and or adapted forms as we have just seen. As to the staff, we actually started with very few examiners that were prepared for Office of Origin work. They were dedicating part-time because we knew that we needed to be ready on day one for the Office of Origin work, whereas for the work on designations, we had a bit of time ahead of us. So we actually concentrated on that part for the day one, and we asked volunteers, and we chose examiners that had a good understanding of NIST classification and had the adequate linguistic profiles, because we knew already where we were going to receive more, in which languages we were going to receive more applications. So we needed to be covered for those languages as far as possible. And also among our criteria for choosing the examiners, we needed to have people on board that were able to work under time pressure, because Madrid has lots of deadlines to respect, so you need to be careful, and this was really one of the number one criteria. And a good team spirit, because when you work in a small team, you need to be ready to help when someone is absent, take over, because due to these tight deadlines, we cannot leave files staying for long. So any absence must be immediately covered. So for the training of the staff, what we did is that they were involved from the very beginning in the preparation works. They participated to one of those seminars that WIPO is organizing regularly, and at the same time we asked to be able to meet with the examination teams in order to know them in person. It's quite important, we think, to know the people you are going to work with, even at a distance. And then we did a study visit at the UK IPO. They had there some years before us, so they had some experience, but it was not so old, let's say, so it was quite recent. And it was very useful to learn from them what we had to take into account, what to had to avoid. And it was a good experience. Nowadays, all this has changed, of course, because we have ourselves experience. So when examiners are added to the group, we do on-the-job training ourselves. So that's about what I wanted to share with you as to the preparation. My colleague will now take the floor to start explaining our duties as Office of Origin.
Good morning, everyone. It is a pleasure also for me to share this training and all this information with all of you. And as a start, I will talk regarding our duties as Office of Origin and some other topics related to this. And one of the important things is the statistics. As we have talked about the staff we are training and the stuff we need, you can see in line of the statistics we have as an Office of Origin. In the start, we were receiving in 3 months 449 applications, and it was growing and growing every year on. And during the last year, 2019, we have received already 9,621 applications. And we are still growing because for this year, we have an estimation of receiving 10,300 applications approximately. And also our forecast for next year is 10,775 applications. So you can imagine that our group is growing, and not only our experience, because this is really getting very, very more important each year. And of course, we also want to share some statistics that we have taken from WIPO, comparing 3 of the main areas, which are China, the US, and the EU. And also here you can see that the tendency is growing each year. EU IPO has been the first Office of Origin for 10 years, closely followed by the US. But last year, the US became the first filer in international applications. And yes, starting with only a few examiners, now we are 11 part-time examiners here at EU IPO, and we have around 4 full-time equivalents. What does this mean? This means that there are 11 people dedicating to the examination of international applications, but they are not dedicating the whole time to this duty. So they are also working in other areas. And we are counting on their experience also in EUTM trademarks, because they are the basic trademarks for the international applications. And it is also always very helpful. We have a theoretical training on the particularities of the Madrid system in the beginning, and then we continue with on-the-job training and coaching when the examiners start working in this area. As Miriam already advanced, we have developed an online e-filing for international applications in 2017, because EU IPO considered that adopting the e-filing offered by WIPO was interesting, but however, due to the legal constraints of our regulation, we finally opted for developing an e-filing on our own. You see, this is the image of our website, and once the client has a basic trademark application or registration, the international application can be filed online. So they access the online service, and amongst the other options we offer, they can apply for the international application online. Since the introduction of the online e-filing, we have 97% of our clients use the online services to file the international applications. The handling fee the EU IPO takes is 300 euros, but we do not take any fee for the subsequent designations. Also, the payment is important because this date determines the filing date of the international application. It means that if the payment is received behind the 7 days, a new filing date will be accorded to the international application, and this will be the date of the international registration. And regarding the WIPO fees, these, they are paid directly to WIPO by the applicants. In the case we should receive any fees for WIPO, we would reimburse them to the clients. Another technical issue is the numbering of the files. For international applications, we make it very easy. We take the number of the basic trademark, either the application or the registration, which is the same in our system, and then it is followed by the extension _01, _02, etc. And here you also can see an example. This is the number of an EUTM, and it has the _01. one. If the client later on wants to file another international application based on this, instead of the subsequent designation, it will be the _02 number. When we go to the examination of the files, one of the most important things is the handling fee. Once the payment of the fee is validated by the finance department, the new IA file will be ready for the examiner to be checked. And then other important details are verified: the entitlement to file, the limitation to the basic list or the limitation to contracting parties, and other miscellaneous indications like the color claim, the color indication, and the descriptions. Around 85% of the applications are straightforward and forwarded in less than 2 weeks to WIPO, meaning that most of the cases when we go to the examination do not have any deficiencies. So we have a short time lapse to examine them, and then we send them applying our commitments with the users within 15 days to WIPO. If there are deficiencies, obviously we would raise the deficiency letter and we will send them to the clients. So what are the most important deficiencies we find? Obviously the lack of payment, and then we cannot examine the international application. We will send first the deficiency on the fees, so asking the clients to pay the fees. Another important thing is the entitlement to file through EU IPO. Here we encounter quite some problems, but anyway, we are trying to solve them with our clients. But you need to be reminded that companies which are outside from the EU always will need economic connection, commercial establishment within the EU to be able to file an international application. Regarding the extension of the list of goods and services, sometimes it's happened that clients want to ask for more goods and services than they have in the basic EU TMs, and this will also bring us to send a deficiency letter. Sometimes there are missing color indications. If the basic mark has already a color indication, descriptions are added. Now we are asking for voluntary descriptions where there is no description in the basic mark, when the client wants to give a voluntary description. So they are mixing up the fields in our online forms because they sometimes do not know what the difference is. And regarding other issues, it happens quite more often that the MM18 is missing for the United States, the declaration of use, or sometimes it happens that there are differences in the applicant data due to transfers or change of addresses. The time limit we give for the to resolve the deficiencies are 1 month, because this is in order to respect, as far as possible, the 2-month deadline we have to submit the applications to WIPO for certification. As you can imagine, this brings a lot of work to examiners, and we need any possible control not to lose any deadline with WIPO. So we are monitoring our files. In principle, this is done by each examiner through the task they have in their inbox, and further controlled by the managers through daily reports. I will give you an example of how we see our inboxes. Here you can see a view of our tool, what is called the IP tool, and the examiners have the formalities task in the inbox. As you can see here, this one is already with an attention mark because the 15 days deadline is approaching to reach the commitment we have within the office. But most important than this is the dossier deadline, because this is a countdown tool where we can see the days that last until we have to send the file to WIPO within the 2 months. Furthermore, you can see also other tasks, like when the client reply to our deficiency letters, then we get a task called read new mail, and we get some information on the file. And we can see also ceasing of effect tasks and the process IA irregularity tasks. But what is important here, there is no dossier deadline anymore, as you can see. So it will only depend on the task deadline. For processing the irregularities from WIPO, we adjust to the WIPO deadlines, our own deadlines. And these is the aspect of our daily alerts. As you can see, once again, the number of the international application is visible, the filing date, the days it is already in our system, if there is a translation pending or not, and the kind of task which is waiting to be treated. So here we can see that there is all notified formalities deficiency pending and that the file is already 21 days in our system. Other files which are pending translation are also indicated with an yes, and we are waiting for the translation to get back, examine the formalities and send them to WIPO later on. What about the translations into the WIPO languages? As we work in 23 languages, and for the applications which are filed in other languages than English, French or Spanish, we will have to translate the list of goods and services, the specification, other elements like the colors or the descriptions. EU IPO offers the possibility to the clients to provide their own translations, or the client can also authorize the office to use the translations we have in our database, because once the EUTMs are published, the translations are available. And if the translation is not available yet, we would request the translation to the EU Translation Center in Luxembourg. What happens with the WIPO irregularities? We have already examined the mark, we have sent it to WIPO, and now it is time for WIPO to examine the application. So we can receive irregularities on the fees, which will be for the applicant to solve them. And yes, I forgot to mention that you know that WIPO sends the irregularity not only to the client, but also to us. And this is why we have the notice and the tasks in our system. So as I said, the fees need to be solved by the applicants directly, and regarding the classification of the list of goods and services, we do not make any use of the faculty to express any different opinion. So we leave it to the client to reply. And once we get the reply, we will forward its response electronically to WIPO. Then we come to the moment of the registration. Once the WIPO notifies us the entry in the international register, our system processes the information and incorporates the international registration number in our database and updates all the other details automatically. What does it mean? That if there has been any irregularity on the classification, the new list will be integrated into our database. Furthermore, a publication in our bulletin will follow, indicating the date and the number of the international registration. And what happens after the registration by WIPO? What happens to the international application? We obviously still have to monitor any international application during the 5 years dependency period. During the 5 years dependency period, any limitation, a withdrawal, a refusal in ex parte or inter partes proceeding affecting the basic mark, and by extension, the international application needs to be communicated to WIPO. We will send a notification of ceasing of effect with a new list of goods and services to WIPO, indicating also the relevant event and date on which the ceasing of effect has happened. Once WIPO receives this notification, it will be recorded in the international register and then notified to the relevant designated contracting parties. The transmission of changes affecting the international registration can be submitted through the EU IPO as Office of Origin, or they can be submitted directly to WIPO. But it happens very often that we receive those requests for changes of ownerships, renunciations, and limitations. Usually, we only make few checks on these forms, and then we forward it through WIPO. For this purpose, we use the Madrid office portal. I will talk about the Madrid online tools later on and explain a little bit more on how it works and why we use it, because in these cases we do not have any electronic transmission. And this is also very important to bear in mind, that once the international registration has been recorded, we have a 9-month deadline to notify any corrections made by EU IPO or the office of origin case, and to WIPO. This deadline counts from the date of the publication of the erroneous entry in the international register. These notifications are also sent through our system in an XML file. And last but not least, a few words about the subsequent designations. When we receive subsequent designations, we will, as we do not have an online e-filing for subsequent designations, we will make manual key-in of these files and we will send them to WIPO. We started having a lot more subsequent designations because in 2013 we were still receiving 400 applications, but now it is becoming less and less, and because they can use the WIPO online tool, which is very efficient, and so we are receiving only approximately 50 subsequent designations per year.
Okay, so now we are moving to the duties of EU IPO as designated office. So when the European Union is designated in an international registration, it means that the protection is available in all EU member states. We will start as before with some statistics. As you can see, this has been also growing more or less steadily. We had a small decrease in 2016, but in general, we are receiving every year more and more designations. We have also made a comparison with the other two offices, China and United States. As you can see, the trend has been the same for the three offices. We have been second more designated office during many years, and now China is leading. And I suppose this is what will be for the next years as well. We will start with the staff that we have deployed on designated office work. We are actually, the work is quite fragmented in our office. In general, this is also the case for EUTMs. We have examiners concentrating on substance and others on what we call proceedings, which means more formal parts of the examination, including classification or the examination of vague terms. So this is why you can see on these slides all these various areas where we have examiners dedicating. So on the formal requirements, the limited list for the EU, and the examination of vague terms in the list of goods and services. We have 16 part-time examiners, which represents only 3 FTEs. On absolute grounds for refusal, only for the objection, we have 22 part-time examiner, which represents 7 FTEs, full-time equivalents. For the treatment of the manual transactions and the manual grant of protections that we have we have 7 examiners, only representing 1.5 full-time equivalents. In opposition proceedings, 8 examiners, representing 3 full-time equivalents. Cancellation proceedings, 5 examiners, not even 1 full-time equivalent. Whereas on decisions, substance decision on opposition and cancellation, actually all examiners of the operations department are involved, because basically the decisions are the same than for direct EUTM, so there was no reason to make a special team for that. So all examiners are involved. And then we have also a participation from our finance department, which is dealing with the fees that we receiving from WIPO, and simply to make all this administrative treatment. Where we have dedicated experienced examiner is really on the treatment of incoming and outgoing manual transactions for the designations. And it is the examiners that are also working on the Office of Origin work and are very experienced that are dealing with all these transactions, because the use of electronic correspondence make it a bit complicated at the beginning to understand the notification and to know what to do. So we prefer to have really examiners experience with the Office of Origin work to be able to deal also with the designations as far as these transactions are concerned. For the rest, also for the substance examination, but the rest of the proceedings examination as well, the formalities, the examination of the lists of goods and services. These are treated by examiners that do work with EUTMs, but are not really specialized with international registration. So they do know the differences, obviously, of the filings going through Madrid, but they don't have this particular experience that have the other examiners dealing with the transactions. So how do we proceed? Basically, we download XML files directly into our back office every week. This is actually happening every Thursday morning. So our IT team is dealing with that, and the data enter automatically in our back office. The numbering, you might be aware or not, we do not allocate a national number to international registrations. We keep the international number and we simply add a prefix in front of the number so that it's clear in our database that it is an international registration. It can't be mixed with another file, a direct file here. So the numbers are identified this way. So it means that the international registration do not form part of our register. It is WIPO who administers the international register, and our database is a copy of the international register as far as the European Union is concerned. This is logical in our view because WIPO is really administrating everything in the international register. So we couldn't understand why we should give a new number to the filings and consider those filings as part of our register. So the very first step that we take is republication in our bulletin. I'm mentioning republication because actually the IRs have already been published by WIPO in the Gazette. So when we receive the designations, we republish them in our bulletin only for the purpose of creating an opposition period. That's the only purpose, because actually the whole IRs has already been published by WIPO in their Gazette. So prior to this publication, our IT system is automatically making some checks. Basically, if the type of mark is indicated, if there is a second language, that is a specificity of our regulation. We need a second language for opposition or cancellation purposes. And the last pre-publication check is whether there is a limitation for the EU in the file. So all those files will go through a manual treatment for any of those three problems that they might contain. The others will go directly to publication. Our publication is very limited because, as mentioned, we consider that WIPO has already published the IR, so we are only publishing some very limited data, the number, the date, concretely the date of publication in the Gazette, so that the user can consult the whole data, in particular the list of goods and services, because here we will only publish the numbers of the classes and the reproduction of the mark and those languages that I was mentioning before, because this is necessary for opposition. And so when the IRs are published, we start the ex officio examination, which is basically very similar to the one we perform for direct EUTMs. But there are obviously some differences which are due to the system itself. It's clear that in the international system, there is no obligation to have a representative on file, a representative before the national office, unless there is a deficiency. Another difference with direct filings is, of course, that we do not collect payment. We receive the payment by WIPO, and this is also a big difference with our national filings. The classification of goods and services is performed by WIPO, whereas we would examine it in the direct filings. We have a reduced formality examination because WIPO has already performed a part of the examination of the formalities. And we do not translate. In the direct filings, we translate into all the EU languages. This is not the case for IRs. Let's move now to the examination itself, ex officio examination. So during the first month following reception of the designation, we will examine, as mentioned, the list of goods and services, meaning that we are checking vague terms in the list of goods and services according to our practice. So this is not about classification. This is only whether the list contains any vague term according to what we are our understanding of what a vague term is. We have very comprehensive guidelines about classification here at the office, and there is a part dedicated to what we consider vague terms. Then we do accept and examine collective and certification marks, where we need to receive a regulation governing use. And this regulation is expected to be sent to the office within 2 months from the notification of the IR to our office. So we will wait for these 2 months to see if we receive this regulation of use. And if we don't, we will issue a provisional refusal, where we will ask to appoint a representative if necessary, if the holder is from outside the EU. Same for the absolute grounds. This is the examination is made the same way as for direct filings. We will see in the next slide that we have what we call an initial central examination, where all the filings, being direct filings or international designations, go through a team of examiners that will examine, they do a first screening, let's say, of the absolute grounds, and they will be able to accepting the straightforward cases and put aside the cases where there are doubts, and that should be examined by decision takers who will then decide whether or not the file should be objected. So this is an initiative that we launched in 2017, and is composed of a group of experienced examiners that work together. In the slides, you can see the room. Of course, this is not the case anymore due to COVID, but it used to be like that. They were together in the same room with screens in front of them. And so they were doing this pre-screening of the applications as far as absolute grounds is concerned. So nowadays they work from their offices, but they do meet at the end of the morning to share their doubtful cases and to come to a decision. It has been a very good experience for us. It has improved the knowledge sharing and the quality of the decision. So, coming back to my slide on ex officio examination, once we have made our mind on the vague terms, on the absolute grounds, and if it is collective certification mark, we have been able to check the regulation of use. If all these steps are positive, we will issue an automatic interim statement. This is made automatically by our system once we have validated the three tasks, or if there is any problem detected, we will issue provisional refusal. Provisional refusals have, all provisional refusals have a time limit of 2 months from issuance of the provisional refusal by our office. You might know that this is a question that is looked at the moment by the Madrid working group, the questions of time limits, because it's very different from one office to another. And so the working group is trying to harmonize, and this is on the table for a couple of years now, and hopefully we will be able to reach an improvement in this regard, because it is indeed difficult for applicants to know the rules in each office. So for the time being, our time limit is these 2 months from issuance of the provisional refusal, that we allow quite easily extensions of time limit, because we are aware that the applicant has not been able to have a full 2 months, let's say, to respond to the provisional refusal, as by definition, the provisional refusal goes through WIPO before they reach the IR holder. So we don't make any difficulty in granting extension of time limits. And we do also offer the possibility to apply for continuation of proceedings if an IR holder has lost the time limit it had been granted by the office. Coming now to professional representation. So as we said, by definition, in an international registration, there is no need to have a representative in the files. When we receive those files, many of them do not have any representative, and there is no problem with that. The appointment of a representative only becomes compulsory when we issue a provisional refusal. Obviously, if the IR holder is not within the territory of the European Union. When we issue partial provisional refusal, and there was a need to appoint a representative, if we don't receive any reply, we will not refuse completely the international registration due to this lack of representative. We will only refuse as far as the extent of the provisional refusal, at least in the area of ex officio examination. So coming now to relative grounds, we do not examine relative grounds ex officio. So we will not go through any possible earlier rights in our database. We leave this task to third parties through a 3 months opposition period that we open to the owners of earlier rights. We have not made, when we adhere to the system, we have not made any declaration under Article 52C of the protocol, meaning that we do not extend the refusal period because there is an opposition. So we still deal with opposition within the 18 months deadline. If we have an opposition, we receive an opposition while there is still an ex officio provisional refusal pending, we suspend the opposition procedure until the ex officio procedure is concluded. We suspend after we have issued provisional refusal, because obviously we cannot lose the 18 months deadline. So we do secure the provisional refusal, and then we suspend the procedure, the opposition procedure, until the ex officio refusals are concluded. So that's the way it works. So we mentioned before, after the publication, we have this 1 month time limit that we dedicate to the ex officio examination, as we have seen before. And then we have this 3 months opposition period starting, so which goes from the end of the first month, so from the second month to the fourth month, where third parties can present oppositions. So the opposition procedure is divided basically into 4 steps. The first one is the admissibility check, because we will notify provisional refusal based on an opposition only for admissible opposition, which seems quite logical. And then once the opposition is considered deemed admissible, then it proceeds further into the procedure, the opposition procedure, which is basically 3 steps, what we call the cooling off period, which is a 2-month time limit period for the 2 parties to try to reach an amicable agreement. This cooling off period can be extended up to 2 years. And then if by the end of this cooling off period there is no agreement, the files go ahead to the adversarial part of the proceedings, where each party can present its arguments, and these are exchanged between the parties. And if we still do not have any agreement, then the file is ready for a decision to be taken by the office. So upon receipt of the opposition, we issue a letter, basically, to the IR holder or its representative, even if located outside the EU. So we do inform the IR holder or its representative that an opposition has been received. And if necessary, we advise that if the opposition is admissible, they will have to appoint a representative before the office if they are located outside the EU. So that the very first step, we do inform already that a representative might become necessary later on. So it's informal at this stage. So if we do not get any representative appointed within the time it takes before we send this informal letter and the moment we reach the end of the opposition period, if no representative has been appointed, then we ask formally to the client to appoint a representative within a time limit of 2 months. This is the formal request. Then if no valid representative is appointed to this formal request, then the designation will be totally refused, even if the opposition was only partial. So this is a big difference with the ex officio refusal, where we were refusing only partially when the provisional refusal was for part of the goods and services. In the opposition procedure, even if the opposition is partial, we expect the IR holder to appoint a valid representative. Otherwise, the designation is totally refused. For the rest, the opposition procedure is following the same procedure than the opposition against the UTMs, with the only exceptions of the limitations and the renunciations, which are obviously different in the Madrid system. As you know, limitations in the Madrid system are supposed to be requested through WIPO, because WIPO is administrating the register. However, we do accept to receive limitation directly with before our office in reply to a provisional refusal. But in this case, we will not consider that it is a limitation. We will consider that the provisional refusal, the partial provisional refusal, has been accepted by the client. And this is what we will send in our grant of protection to WIPO at the end of the procedure. We will confirm the partial provisional refusal. This is the only way that we can accept direct limitations and keep the essence of the systems which request limitation to be filed before WIPO. On the contrary, for renunciation, we do not accept to receive them directly before our office. They need to be filed through WIPO, and when we receive such requests, because we do receive such requests, we advise the clients that they have to file this renunciation before the International Bureau. Let's come now to some statistics about deficiency rates within our office. On these slides, you can see the deficiency rates for the examination of the list of goods and services on vague terms, the absolute grounds, and the formalities. As you can see, formalities is very, very low. It's less than 1%. The objection rate on absolute grounds is around 4%. It's always slightly below the objection rate that we have for direct EUTMs. We always wonder why we have this difference, but it's probably because with the international system, where we have the 5 years dependency, probably the applicants are more cautious when filing, and so we have less problematic cases. For the vague terms, as you can see, this year we are around 7%. We used to be, yes, around 8% of all filings. On this slides, you can see as well a difference between oppositions against direct EUTMs and opposition against IRs. We receive less opposition there also. We suppose for the same reason, that the applicant are more cautious with the international registration. I mean, it's supposition because we don't have any real study on this, but this has been the case since the beginning. In the next slide, you will see that our opposition rate is actually going down. This is altogether opposition against EUTMs and IRs. So since 2010, you can see that it has been less and less, which is good news. It means that there is conscience from the awareness from the applicants. They check earlier rights before filing, and so this is good news. Then we are reaching the end of the procedure. So all accepted designations are republished in part M3 of our bulletin. And this is the starting point of the 5 years use period from which the registration may be also invoked against infringers. This is also very limited publication, as you can see. And once the accepted designation have been published, then it's the time to issue our outcome, basically to WIPO. So if no ex officio refusal was issued and no opposition received, the statement of grant of protection is generated automatically after the end of the position period plus a buffer period. This is completely automatic, and we do not issue a certificate of registration because, as I mentioned before, we do not consider that the international registrations are part of our register. We do only issue the statement of grant of protection. On the other hand, if one or more provisional refusal had been issued, either we have refused totally the designation, and this is the decision that we will send manually to WIPO, or we are granting the protection in part. And this is also a statement that we generate manually once all proceedings are completed and appeal exhausted. Here we are showing you an alert that we have in our database. So it's the same database as my colleague has shown you before for international applications. So we work with task, and this task is one of the very important ones. We have a task appearing in the examiner's agenda 1 month before the expiry of the 18 months time limit, to be sure that we're not losing any deadline there. And it has proved to be very useful, I must say, because sometimes examiners think that they have issued and maybe the letter has remained in generated but not sent, or there has been any IT glitch and the letter was not sent to WIPO. So it has been very, very useful to have this alert 1 month before the expiry of the 18-month time limit. So let's come now to some features of the Madrid system. Let's talk about transformation, which originates from Article 9 Quinques of Madrid Protocol and serves the purpose of softening the effects of the central attack, which may lead to a ceasing of effect of the international trademarks. So, as you know, transformation is available 3 months from WIPO recording the cancellation, total or partial cancellation of the IR at the request of the Office of Origin. So in our office, this works as the filing of a new direct EUTM claiming the transformation right. We have a part in the EUTM application dedicated to this transformation right, where the applicant has to indicate the IR number, the cancellation date, the IR date, and if there was any priority date in this IR. One important feature of the transformation is that if the IR was already registered, finally accepted, when it was cancelled at the request of the Office of Origin, we will not go through again re-examination and new opposition period and so on. We move this new EUTM application with the transformation right directly to our register. It will not go through a new examination. Whereas if the IR was not yet finally accepted, then this new UTM application will go through normal examination and an opposition period will be created again. Other task as designated office is about replacement. We will not spend much time on this issue because the number of cases is extremely low. I think in the 16 years that we are in the system, we have received a bit more than 20 requests of replacement, so it's not very popular. However, the protocol, the regulation on the protocol on this feature has just been amended and clarified, so we might get more cases in the future. We will see. On the other hand, I would like to spend a bit more time on the treatment of changes, as it is quite an important task for us to perform in terms of volume that we receive every year. And as I mentioned before, this is a task that will live in the hands of experienced examiners. One of these transactions that we received from WIPO is obviously about limitations, partial cancellations, and partial ceasing of effects. Altogether, we receive more than 3,000 every year. About limitations, we do examine them, and if they are not acceptable according to our practice, we issue declarations informing that the limitation will have no effect in the territory of the European Union. Another very important transaction in terms of volumes that we receive every year is corrections, which can be corrections of the designations data of all kind. We can go from a very simple typo corrections to the applicant address or to more important corrections concerning the extent of the protection. So it can happen that we receive corrections about the list of goods and services, adding classes or goods or services in the specifications, or even corrections concerning the trademark. So altogether, these corrections amount to 1,500 per year. I'm really considering here all type of corrections that we can receive. Obviously, these corrections may have an impact in the examinations, because sometimes it's clear that if the correction is about the list of goods and services or the trademark, we might need to re-examine or even republish for opposition purposes. And sometimes it may even have an impact on open opposition procedures or examination procedures. It's clear that if we receive a limitation that had allowed us to close an opposition, let's say, and then we receive a correction telling us that this limitation is null and void, it's clear that we have to reopen the opposition procedure that we have closed. So the impact can be serious. So we have to be very careful with all these corrections. Then we come to the automatic transactions, which is a big relief for us. We do receive automatic transaction that will enter into our system and update the status of the designation automatically, or in the case of change of names, transfer, that will update the data of the IR holder automatically. I say it's a big relief because it's also quite a high volume of transaction that we receive every year, and so it's really good that this can be done automatically. It helps us a lot. And then I will finish on invalidation. We can receive revocation application or invalidity application both on absolute or on relative grounds before the office, exactly as for direct EUTMs, as well as sometimes we are informed of infringement proceedings. And in those cases where when the procedure is final, we inform WIPO of possible total or partial invalidation of the IR. That concludes my part on the designated office.